So, Pierre, are we live? Okay, thank you very much. We'll call to order just a concurrence conference on Senate File 34, first of all. And let's deal with that one. We have also Senate File 35. A couple of us on one and a one or two on the other, but I think as members of our Judiciary Committee, we can work this out. So Senate File 34, over on the Senate side, we felt like we had an opportunity to fix one of the pieces of that bill, and that was that the one offense is a lifetime offense. We felt compelled to pull that back into a second tier, which would require a report for 25 years versus a lifetime. And the House pulled that back out of the bill. And so I guess our curiosity was just the reasoning behind that. You know, I've kind of shared what our reasoning is. And Senator Case, I hope I described that adequately as we dealt with it.
Mr. Chairman, yes, I agree. I think we shouldn't tie this to any one individual. Doesn't really have to do, it's just kind of a general policy. I think we felt that there was a chance to do some good work, that this didn't, when you compared it to the other things, and that, I mean, truly, I think the sex offender registration needs a big look. It's a mess. It really is a mess. This is a marginal improvement. So I thought we could take the blow.
Yeah, I think there's a lot of sentiment on that. And Representative, hang on just real quickly.
No,
just as a 30,000-foot view, I almost brought that, but I thought, you know, for an interim, that would nearly be your entire interim to take that up. I feel like we've got some real inconsistencies in those statutes. This particular one arose out of some testimony, but really, the more we looked at it, we just felt like it was misplaced. But go ahead, Representative Oakley.
Thank you, Mr. Chairman. So I think, you know, there certainly is some discussion that we could look at the sex offender registration and how the different offenses are categorized. One, I guess two things. As it relates to the statute that we were trying, that we discussed in the interim, and then of course in this bill, it's been said that it needs, you know, it needs a fix. It was misplaced, and so first of all, I would want to push back on that, because the entire point of that statute is position of authority, that you were talking about doing a sex offense with a child and you were in a position of authority. And so the thought behind that is that they not only slept with a child, they used their sphere of influence to do it. And so this category is one that we see true predators on. And so there is certainly thought, and it's not necessarily inconsistent to have that as a high registerable offense. So first of all, I want to push back that we're wrong. We got it wrong. It's misplaced. Not necessarily so. Then you go to the intent of this bill. So the next step, I feel in a little bit we got derailed by humoring that, if you will, as much as we did, because that's not what we were trying to do here. What we were trying to do here is make sure that we are compliant with federal law called SORNA, the Sex Offender Registry Act, so that there is, what am I trying to say, parity, like what we've been discussing, to make sure they're fair, like there's standards. Right now, we have statutes that, like sexual servitude of a minor, that are not even listed as registerable offenses. Makes us out of compliance. That's what we're doing with this bill. So what we did is say, hold on. I don't think that necessarily that statute needs a fix, but we can have that discussion. We can have the discussion about all the different offenses at the appropriate time. This bill wasn't it, which is us trying to do it kind of off the cuff is how we got a little off track. So we went, whoa, we're not going to touch that right now. It is not something that is so blatantly unfair that if we don't fix it right now, there's a problem. So we took that out. We stuck with the original intent of the bill, which is what I think we should do. So we didn't just make a mistake. I just want to make that clear. We very much analyzed what we think we're trying to do with this bill. And so that's what the House did.
Thank you for that, Representative Oakley. Senator Case, you and I are here on this one, but any questions? Any concerns?
Well, Mr. Chairman, she's right in a lot of ways. The position of authority thing is tortuous in some circumstances and pretty tenuous. You know, literally, are you in a position of authority over me right now? You kind of are.
Certainly,
Yeah.
absolutely.
Yeah, I mean, and, you know, being a shift manager in a retail establishment over, you know, it's just, come on. So that is something that isn't working very well. And that, did we do harm? We allow someone to petition the court. You know, it's not an automatic release. So if this pushes us closer to an interim look, and I actually think we should take it up, honestly. It's as important as anything we heard about today. And it affects a lot more people. And you could use a subcommittee or there are different ways to do that. So I'm not trying to trade for that, okay? Let's be clear here, but it does need look. And this statute is open and in front of us, and it's an opportunity. But the representative makes a good point. I appreciate it.
Yeah, really appreciate it, Senator, and I feel the same way. I mean, there's some very compelling arguments that you make. Catching something on the way through, I get that. Sometimes it's just not a good idea. We thought on this particular one, we had an opportunity. We spent time receiving testimony in the interim, and then the more we thought about it, the more we thought we had an opportunity to fix. But I don't want to lose the bill because I think it has some merit, and we wanted to get that through. So,
Well, is there any way to go back to the, didn't we have something about 8 years previously? Is that what you guys did?
yeah, go ahead, Representative Oakley.
Thank you. Yes, so during interim, that is what we discussed, and trying to do a fix, we did 8 years. And I'm trying to be careful here, but then you guys stripped the 8 years out. And I think possibly maybe because of some testimony that you received from an individual, but that wasn't enough for it to help him. So, I mean, I really am not trying to, but that was gone. And that is one of, I'm not sure that we were appropriate even to try to necessarily be fixing this. But even then, we did try. And then we did 8 years. Then it was found that 8 years wasn't long enough, so you guys stripped the 8 years. And then it was kind of like, okay, we're not getting there with this. We tried, it didn't work. We dropped it.
Okay, Senator, I'm feeling pretty beat up.
Pretty beat up, are you?
Geez, I've been rolled before, but I tell you what, never that quickly. I think we can probably head back up and convince the body over on our side that maybe we'll have to revisit a couple of things later. So is that kind of where you're coming from, Senator Case?
I might stand my ground and stomp around, but probably you're right.
And just so you know, the good senator who couldn't be here, she probably feels pretty strongly with that. So anyway, so we'll take that one back, and that's plenty of time spent, I think, on Senate File 34. Thanks for helping us to understand what took place on the House Act.
Can we be clear for the record exactly what we're amending out or amending in or?
Yeah, so, go ahead,
We
Senator
delete
Case.
the Senate amendment.
Yeah,
And that restores the 8 years, is that right? That would take a further amendment.
so Representative Crayco.
I think I think Senator Case is correct. We cannot do that because that was not part of the bill that came across, and all we did was go back. We didn't address the 8 years, and we just struck the language regarding that, the movement of that, because it wasn't before us.
Could, Mr. Chairman, just
Senator Case.
cut to the chase? Do you guys support the 8 years, and could you sell it?
Representative Oakley.
Thank you, Mr. Chairman and Senator Case. Kind of for the reasons that
Same.
that I stated, I just think, I don't think it's appropriate that we're throwing that in. I think it needs a serious look. There is absolutely a belief that this position authority is significant, and of course, that means a jury and/or a judge found them guilty of it, that is one of, in many instances, that is a very serious offense. And so I think we need bigger discussion on the registerable sex offenses and what that means. And so I just think it's appropriate that we don't do it. And let me just throw this out there. I mean, after you're a convicted sex offender, I mean, so you have to tell them where you live. I mean, we are not talking about that you go back to prison, so, something like that. This isn't, the consequences just aren't that severe, and I just don't think we should do that here.
Representative Crayco.
Thank you, Mr. Chairman. I was just I agree with Representative Oakley that this is a bigger discussion, and so I would echo Senator Case's, request, I guess, if that's what it is, to make it an interim topic. I'm not afraid of taking it on. I think it's a big deal, but I also agree with him that this is an important thing. It affects a lot of people. I'm not afraid of that, and I would be glad to help him work on that if that's something we could do.
Mr. Chairman,
So Senator Case.
I hear the House members loud and clear that there's no future in going to a free committee and trying to, but I also I'm going to push back a little bit. It's not just telling people where you live. It's telling the public you're a registered sex offender without any, no, it's a scarlet letter that's available online that everybody knows you're a registered sex offender without any qualifications about the circumstances. I think that's a very severe penalty potentially. It may be appropriate in some instances. That's the problem. That's why we need to be in the interim.
So I think the co-chairman and I have both written down some notes on Senate File 34. And we'll see if we can take this upstairs and sell it on our side. There's some good measures in the bill. So that's it on Senate File 34. Mr. Co-chairman, you got Senate File 35.
Senate File 35, we got the whole 13 minutes to wrap this one up. The House side, the concern was over the approval of the Attorney General's requirement on the Department of Corrections investigations files. And I'm looking for an understanding as to why we'd require the Attorney General to weigh in that circumstance for that department and not for others. And I think there might be some more concern just with the language, the way it's worded. So an explanation on Senate version.
Mr. Chairman, this has to do with public records, whether these files are public records or not. My hope was to get it out of one agency making that determination and to get a third party to look at it. That's why, the bill proposes that the investigations of this division would be exempt to a large extent from public records requests. And I am asking that we just have someone look over their shoulder and that basically, the Attorney General approves sealing the record. Case by case.
Representative Craigle.
Thank you, Mr. Chairman. So it was my understanding we were only dealing with investigative files, not all files, and it's just those files. Typically, it's going to be where the Department of Corrections is probably doing co-investigation with another law enforcement agency outside, not necessarily, but a lot of times they're going to be doing investigations with law enforcement outside one of our penitentiaries or one of our facilities. And so it's truly about criminal investigations. What's, the rest of these bodies also have to they have the right to withhold those during the investigation period. I mean, after that's over, it's a different story. And I think that's all they were asking for is they have issues there when, especially on these co-investigations where they might be working with the law enforcement guy in my county, and they know about communications going back and forth within the department with an inmate, and now their records would be subject to public disclosure, but my sheriff's records or police chief's records would not, because it is an investigation. I think that was the loophole we were trying to close. I don't think it applies to all business records, just those, the way I read it, and maybe we can clear that up, but just those records pertaining to criminal investigations. And the director's here. I mean, we could ask him questions if we needed to.
Senator.
Mr. Chairman, this is an internal investigatory group. They're not an independent law enforcement entity. They are totally internal, and they are not this peace officer trained. They're a different breed of cat, and they're totally within the purview of the director or their supervisors. So it's a closed set. That's where we need to get Director Shannon up here, but the idea that having the Attorney General's office look over the requests or not is just a third-party kind of check and balance eyes. And at the time we proposed that and implemented it, it was indicated that that wouldn't be too burdensome. I mean, these aren't regular law enforcement. This isn't a sheriff's department or this is a 100% internal investigatory unit, 100% controlled by the hierarchy, 100% insular from public scrutiny, 100% all the way, as probably it should be, except for this is a safety valve, a safety check, where the Attorney General would approve or not approve. And it doesn't, and it's not literally the Attorney General, it's the office or whatever.
Director Shannon, why don't you have him come up real quick? Representative Oakley, comment?
Yeah, thank you, Mr. Chairman. While the director comes up, one of my concerns, and you just addressed it, and we didn't talk about it, but go ahead, but was if this impacts expediency, and one of the, you said it wasn't too cumbersome. A concern of mine was that it might be, and so I'm interested in that.
We'll find out.
Director Shannon, can you concisely fill this in?
Mr. Chairman, committee members, thank you. To address Senator Case's concerns, when we develop policy, when we would ask for a judiciary review and in-camera review, it's always referred to the Attorney General's office. That's what we do. To me, the most important thing is to ensure not only our inmates, but our staff. We deal with investigations. We do a lot of investigations for people on supervision that involves criminal activity. It involves witnesses, it involves victims, and even in other states. So my concern is to make sure people are safe, and we'll comply with whatever.
So Director Shannon, does having the Attorney General review unduly complicate or undermine your efforts?
When an investigation request, we have to respond within 7 days. We have to turn the material over in 30 days, and the Attorney General always complies with that. A lot of times during an investigation, not often, but there are incidents where during an investigation, an outside law enforcement agency is requesting information at the same time the inmates or those who are actively involved are trying to get that information. So it does.
Representative Oakley.
Thank you, Mr. Chairman. So basically what I'm hearing, I know it puts you in a difficult place, but I mean, it seems maybe unnecessarily taking away your discretion for some action where you don't feel like you need direction from the Attorney General. So right now, I guess what I'm hearing is that if needed, the Attorney General is your counsel, but there might be some of these cases that 7 days is fast, that you don't feel like you would need that outside counsel. Is that fair?
Director Shannon.
Mr. Chairman, Representative Oakley, I don't think it involves my discretion. I appreciate the question, but to me, it's not about my discretion or my decisions. I think we base our decisions on, are we going to corrupt a case? Are we going to get someone hurt? So therefore, I'm willing to do whatever we can to make sure.
Mr. Co-Chairman.
We've really put this guy in a bad box.
Yeah, this is
Poor
tough.
guy.
Director, thanks for your honesty.
Thanks for this gift, yes.
You know, I just, speaking on behalf of Senator Cooper, who couldn't be here, we worked very hard on some sunshine laws here a 3 years ago. The good chairman of corporations and me, and so on the Senate side, that's pretty near and dear to the heart. Just the fact that we may have a request, and if it's semi-legitimate, give the director the opportunity to send it over to the Attorney General and say, are we okay to withhold this? I mean, we have put ombudsman in place. We have stood up, transparency laws that were hard fought. So go ahead, Director.
Mr. Co-Chairman, if I may, I just would have one comment. We received, anecdotally, I think we received over almost 1,000 requests for public information in tens of thousands of documents. I think we had one case that was referred to the ombudsman, then settled. Maybe there's a misunderstanding of what we're asking for. What I'm asking for, by doing this, what this does is provide a judiciary review. It doesn't mean it's not going to be turned over. It doesn't mean that the parties aren't going to get it. It provides us an opportunity to say, wait, an active investigation's taken place here, and you're going to risk people's lives. Therefore, we need to slow down and have a court to look at this. It's not that the Director of Corrections is saying, you're not receiving this, and I made that decision. This provides us an opportunity to say no, with the Attorney General's approval if need be, which is what we do now. We prefer this doesn't take place, and we ask the court to look at it. Because a lot of times you have those who are actually involved in the crime or participants requesting the documents.
Mr. Chairman, I do think we're on that page, so. go
All
ahead.
right, we're tight. So Representative Craigo and then Senator Schuler.
Thank you, Mr. Chairman. I was going to echo what the good director just said. There's already a procedure. So if you deny the request, you have to do so in writing. They then have the right, whoever the requester is, to appeal that. I was going to follow up. Do you run all of these public records requests by the Attorney General anyways? So whether the language, my initial thought about the language was not that I think that the director shouldn't consult with the Attorney General. It just was clunky. It didn't read right to me when you read the language in the bill. And I'm not opposed to him running that by the good Attorney General. That was not really our concern, or having someone else look at it. But also there is already multiple levels of that. There's the new sunshine laws, as you mentioned, Chairman Landon, and then also the appeal right. You can go to district court if someone doesn't give you the documents, and it's a very quick turnaround in district court under the Public Records Act.
Senator Schuler.
Thank you, Mr. Chairman. I got a frog in my throat, but I think when we talked about it, this particular bill, and certainly, it seems an easy fix either way. We weren't really thinking in terms of expediency, we were thinking, I think, in terms of really, do we need the oversight? Do we need that third party? Do we need I mean, we're talking about criminal investigations, so it's really important. And in that situation, I don't think expediency is the number one concern. It's really, do we have it right? And so that was really our big concern, I think, when we talked about it.
All right, do we have a consensus? I'm not sensing one. What I heard was the, go ahead, Representative Craigle.
I think we can live with the language if the good director says it's not going to cause issues. I just don't like how it reads, and I'm picky about that. But if it's doable and the director says it's not going to cause problems, then I think I'm fine with that.
Okay,
Representative Oakley, do you?
Well, I would kind of want to fight some more. Can't we do that? Look, you guys won one, we won one. Let's.
Go
Yeah,
upstairs, there's lots of fighting done up
I don't like
there.
that result. Let's keep fighting.
All right, so the House is going to leave the Senate amendment in place.
Okay, and we'll do the same on our side. How about that? Thanks, you guys.
But we're not log rolling. This is not log rolling.
It's like kissing your mother-in-law. Okay.
Representative Oakley, have a great day, will you?
Thank you, Director.